Welcome to Shooting Straight, LeoNF.com. I'm Frank Miniature, the editor-in-chief of the Editor's America's First Freedom. Today we have the pleasure again of speaking with Stephen Halbrook. Now, Steve is a senior fellow with the Independent Institute. He's a contributor to America's First Freedom. My favorite book of his was, at least his latest one, America's Rifle, just a fantastic read and an important book. He's argued 3 cases before the U.S. Supreme Court and won them all. And lately, in November, he went and he sat in the hearing room as the Supreme Court heard United States versus Rahimi, which is a difficult case. I wouldn't want this individual as my neighbor, but the question here isn't about his conduct. The question here is a constitutional one. Steve, please get into that.
I think most of your viewers realize that the previous Supreme Court cases, I'm just going to mention them sentence by sentence just to see where we are now. District of Columbia versus Heller, the Second Amendment protects individual rights of law-abiding citizens. It protects commonly used firearms like handguns. Then we had McDonald versus Chicago. Yes, Chicago, the Second Amendment applies in your city through the 14th Amendment. Then we had New York State Rifle and Pistol Association versus Bruin from last year. These cases just keep getting better. These Supreme Court decisions keep getting better. So the Bruin case says that there's a presumption if the activity you're involved in is within the plain text of the Second Amendment, then the Second Amendment protects it. So the right of the people to keep and bear arms shall not be infringed. If you are among the people, that means you're in the United States and you're not an illegal alien, you're a citizen, for example. Arms include ordinary arms, such as are protected by or possessed by law-abiding people. Are you keeping it or are you bearing it? And so all of those things create a presumption that your activity is protected by the Second Amendment. The second thing Bruin held was that for the government to prevail on a restriction, they have to show that the law, the restriction, is in our historical tradition of firearms regulation. For example, if at the founding or the years after the founding, when the founders were still around, for example, if it was a kind of law like they would have had then it would be encompassed, it would be an exception to the Second Amendment. So if you had a typical example, because they had laws on this, going armed in a manner to terrorize other people, you could certainly make a law against that. That's actually a common law offense that went way back in English history and was adopted here in the United States. And it's still a crime, but just with other terminology, like brandishing a firearm, creating apprehension by other people that you're pointing it at them or otherwise terrorizing them. So those were the tests. So then we come to the fact that federal law prohibits certain kinds of persons from mere possession of a firearm. And first on the list is a person convicted of a felony, typically defined as convicted of a crime where there's been as much as, or rather more than 1 year incarceration possible, not necessarily imposed. Then we go down the list in different other provisions like a user of illegal drugs. Now that's an interesting one because Hunter Biden just filed a motion to dismiss the prosecution in Delaware claiming Second Amendment rights while his father's running around trying to destroy the Second Amendment. He's claiming he could be an illegal drug user, and that's protected. That's not the kind of law that can be a restriction on Second Amendment rights just by being a user. So we'll see what happens with that. But then we go down the list and we find number 8 on the list is a person if they are subject to basically a domestic protective order, if it's got one of 2 elements imposed. Number 1, if there's a finding that you are a danger to a person in a domestic relationship, or number two, if there's a court order saying that thou shalt not commit violence or otherwise threaten a person in a domestic relationship. So for the first one, the court actually has to make a finding of dangerousness. For the second one, there simply has to be a court order. And people get divorces all the time and they agree to things like, I agree not to harm you, you agree not to harm me. Who wouldn't sign something like that? But if you sign that, then you're going to be under this provision where you're prohibited from having a firearm. So rahimi.
Wait a second. Is that state and federal law? Or I'm a non-lawyer and I'm a little confused there.
Yeah, we're talking about federal law. But you get the protective orders are entered by state courts. But if a state court enters such an order, then federal law says you cannot possess a firearm. So let's go to who's Zaki Rahimi. He's not the kind of guy you'd want to have living next door. A protective order was entered against him, not to harass or to attack or anything like that, his ex-girlfriend. So that was a civil proceeding. It was not a criminal proceeding. And it was entered really without even having a real hearing. And so that's the record we're dealing with. Now, after that order was entered, he goes on a shooting spree where he was at a fast food place and a friend of his credit card was rejected. And so he fires some shots in the air and he goes around like a loose cannon. And so he's being prosecuted in the Texas state court, the Texas state courts for those offenses. And even the protective order under Texas law, he cannot possess a firearm there. And so it seems like all is good. In other words, you can prosecute people under state law for all kinds of things, including everything he's done. But the feds always have to get involved. They've got to show we're doing something. And so here they get involved in domestic relations. And so they say, if there's a state court order, a protective order of the kind that we've talked about, then you cannot possess a gun. It's a felony for you to possess a gun. So that's what Rahimi's being prosecuted under federal law. Now, if you go to the U.S. Court of Appeals for the Fifth Circuit, they made a decision that the federal law is invalid. They didn't say anything to invalidate the state law. That's not even an issue here. All is well in terms of prosecuting people for crimes or even for having protective orders. But what happened here was that the federal government thought that even though he was incarcerated and facing all these other charges, we've got to step in too. This law was passed back in the 90s. It was passed before the Supreme Court had rendered the Heller decision. And Congress wanted to get involved in, we're protecting people who are victims of domestic violence, even though that's a state law issue. And what the Fifth Circuit said about that was, just hold on right there. You can't make it a federal felony to possess a gun, to deprive somebody of Second Amendment rights, solely on the basis of a civil proceeding. If you want to have a criminal case, convict them of a felony or a violent crime, whatever, then certainly most state laws prohibit possession of a firearm.
Was there any due process? I mean, did he have an attorney? What happened in that courtroom?
Well, in the civil proceeding, he had no attorney. And the way this normally works in civil court, we're talking domestic relations court. Typically, you go in that court maybe without an attorney, maybe without any process, including where the court actually makes findings, actually hears evidence. None of that took place here. So the Fifth Circuit said, this law is invalid because it's only based on a civil proceeding. If you want to convict this guy, bring a criminal case. If he's acted violently, convicted of assault and battery or wounding or whatever he's done. But you can't just go to a civil court where the only standard is called a preponderance of evidence. And that means that, well, it looks like the complainant should win because there's just a tiny bit of evidence in the complainant's favor. And also, as a judge, I don't want to be criticized if something happens and I don't enter this order. And so that's what typically happens. There's no proof beyond a reasonable doubt. There's no guaranteed counsel. There's no right to a jury trial. None of this exists. So that's why the Fifth Circuit said that this law is unconstitutional.
Well, did it come out at all? I mean, is this a U.S. attorney or is this from the Department of Justice that's trying to set a precedent? Is that what's behind this? What's driving this? Because he's right now he's in the state court facing the charges that for the alleged crimes that he's committed. So what's going on here at the federal?
Well, Attorney General Merrick Garland couldn't wait to get this case to the Supreme Court. He didn't even ask for a rehearing in the Fifth Circuit. The facts are bad. And so he likes that. He wants there to be an adverse decision on the Second Amendment or something to restrict Second Amendment rights. So he hustled up to the Supreme Court and knocked on the door. They weren't even open yet. I mean, it was like midnight.
By facts are bad, you mean this individual is a deplorable, he appears to be a deplorable person.
Yeah, right. So they couldn't wait for the court to get this case instead of a case where the facts are more favorable. Because there's one such pending case that I'll mention in a minute. So he was just gleeful when the court accepted the case. And at the hearing, I've got to tell you some of the things that came up at the hearing. It was a very interesting case. Basically, at the lowest level, district court, you have a federal prosecutor, obviously, and then in Court of Appeals, you move up the ladder to someone in the U.S. Attorney's Office or maybe the Solicitor General's office. And then at the Supreme Court level, the case was argued by the Solicitor General, who is named Elizabeth Prelogar. And so she got up there and started her opening statement. And one of the first, she said, we can restrict Second Amendment rights based on if a person is not law-abiding or if the person is not responsible. And that's way too general. But so Chief Justice Roberts, his first question was, if I'm driving 40 miles an hour in a 35-mile-an-hour zone, am I not law-abiding? And she said, no, you have to be convicted of a felony to be classified as not law-abiding. And then he asked about not responsible. So am I not a responsible person if I don't put the recycle out on Wednesday when you're supposed to put it out? And she said, well, no, responsible means not dangerous. So I don't know why she didn't just say dangerous instead of responsible. But
that's pretty subjective.
The way it started out.
Do you have any idea where she's bringing this from? Is this her own opinion, or is this based on some of the precedents?
There's language in Supreme Court cases that the Second Amendment protects law-abiding, responsible persons, but it didn't say the amendment is restricted to those as some kind of ironclad concepts. It was general language they were using. For example, some courts have said, this gets into another case about persons who are nonviolent, but they have a felony conviction. Are you nonviolent if I can't think of the offhand right now the exact example, but something where you violated some kind of law. If you look at the kinds of laws that are felonies nowadays, possession of a lobster that's underweight, or there's any number of things that are felonies under federal law as well as laws of certain states where you're nonviolent, and the only reason you can't possess a gun is because the potential penalty is more than 1 year, or in the case of a state law, it's more than 2 years. But anyway, getting back to the Supreme Court argument, Justice Thomas asked the following question, because remember, we're looking at precedents or the kinds of laws that were considered allowable at the founding for restrictions on Second Amendment rights. And in the court below, the government was arguing that, well, we had the slave codes, and it was illegal for a slave to have a gun. I mean, imagine making that argument. And so I guess out of embarrassment, they dropped that argument in the Supreme Court. And Clarence Thomas asked, why all of a sudden are you dropping that argument? You've been arguing that all along in this case and in other cases. And the Solicitor General just kind of made an aside comment like, well, we're only talking about laws that apply to citizens, and slaves weren't citizens.
Didn't you note in the article for us that it still appeared in their amicus brief?
Oh yeah, the amicus brief supporting the government, several of them relied on the slave codes, and they've argued that for years now, that you can have various restrictions because hey, we disarmed slaves or we disarmed Tories. Well, guess what? That was a war situation. The courts were not open. It was mano a mano or whatever. It was like hand to hand. You're trying to kill us and we're trying to kill you. Yeah, we can take your guns away if you're an enemy combatant. And so that was another example they had used before. And then they tried to use laws that state laws that disarmed persons who were unemployed or were considered hobos or juveniles, things like that had no application.
Vagrancy laws, and then you lose your Second Amendment rights.
Right. Yeah, exactly. So it went back and forth, and Justice Alito asked a question about, here you have two different ways you can get one of these restraining orders and make it where you can't have a gun. Number one, there has to be a finding of dangerousness. Or the second way you can get hooked in with this is that there has to be a court order that prohibits you from acting violently against a domestic partner. There doesn't have to be any finding there that you're actually going to do anything or that you might do something. And so Alito said, well, okay, so Rahimi, he checks both of those boxes, but what if a person only checks that second box? There's no finding of violence or potential violence. And the Solicitor General said, well, you need to decide that too, even though you wouldn't have to uphold a prosecution against him under that first element. And so she said, the Solicitor General said, well, unless you want to see me again next year, you need to decide both of those. And Alito said, always happy to see you, General. They called the Solicitor General General. I mean, I know it sounds like, like a military title, but it's not. In fact, the Attorney General, he's called General in a formal situation. So it went back and forth. The Rahimi lawyer made his argument, made the point that there were no comparable laws at the time of the founding, that the liberal justices seemed aghast that they couldn't just prohibit the kind of behavior that's prohibited here, even though, once again, it sounds like at first glance it's a good law. You're prohibiting gun ownership by persons who might be a danger to a domestic partner. But when you start looking at it, there's plenty of state laws to deal with all of this. In fact, at the founding, there were laws against assault and battery, including it didn't matter whether it was a spouse or a stranger. I mean, you still had so many protections at the founding and laws that would justify later restrictions if it was comparable enough. So another issue that came up, I wanted to mention the Range case. There's a case, a civil action involving a person with the last name of Range who maybe 20 or 30 years ago was convicted of welfare fraud. He was having a very hard time making ends meet to feed his family, and he put the wrong answer, a false answer, down on an application for help, some kind of welfare benefit.
It was food stamps.
And he was convicted.
Right.
That's right. It was a food stamp issue. And so can you disarm him forever? I mean, he's lived a law-abiding life ever since. no further convictions of any kind. So that came up in the argument because, okay, he's not dangerous. So, I mean, he's law abiding according to what the Solicitor General said, because he doesn't have a felony. I'm getting the two cases mixed up. Sorry. He's got the felony conviction, but he's not dangerous. Mm-hmm. And so the government's trying to argue that any kind of felony, no matter what, it doesn't have to be dangerous. You're going to be forever denied your Second Amendment rights. And if you think about that, governments can make anything a felony. If you go to certain states, especially the usual suspect states, everything's a felony. And so there's got to be some, if the Second Amendment means anything, there's got to be some kind of rule that deals with, are you a dangerous person? Does a felony conviction reflect that? And if it does, you can be disarmed. But if it's the kind of crime that technically is classified as a felony, but you're not a dangerous person, it used to be in the Gun Control Act, it's still there in print that if you had a felony conviction, you could apply for a relief from disabilities. ATF could do an investigation. If they made a finding that you're not considered a threat to society, you could have your right to have guns restored. But Congress decided back in the 90s that we're not going to fund this anymore. And so there's an appropriations rider saying that ATF cannot spend any money to investigate these petitions for removal of disability. That would solve this felony problem, by the way, if that money was restored. But anyway, that case was decided by the Third Circuit Court of Appeals. They said that this violates the Second Amendment as applied to this individual, to give him a lifetime ban on possession of firearms. And so that case is pending in the Supreme Court. And Justice Amy Coney Barrett asked a question about that issue, and the Solicitor General came back with, I know you're talking about a case that's before the court, and it's the Range case, because Amy Coney Barrett had issued a dissenting opinion in a case called Cantor versus Barr back when she was on the Seventh Circuit Court of Appeals, saying that basically if a person technically has a felony conviction but is not a dangerous person, then you cannot, consistent with the Second Amendment, disarm that person for life. And so that case is pending before the court. The government wants the Rahimi case to be decided first, because they don't want this Range case where you've got a very favorable plaintiff coming before the court and maybe reducing the pain that could be delivered just with a decision on Rahimi. Now,
a lot of the media has treated this Rahimi case as if it's a criminal trial based on the actions. It's not. It's about creating constitutional precedents, which is so important for all of us.
Right. And what's going to happen in Rahimi, of course, there's always speculation. And what could happen, and a lot of people are saying this, is maybe the maybe the Supreme Court will uphold the law, or at least that first part of the law where there's got to be an actual finding of danger, but will do so in a manner that's very narrow, because the so-called liberals on the court don't like the Bruin criteria for the way you look at laws. They don't like the idea that you look at the founding period for what's going to be acceptable and the principles. And the reason for that, by the way, it's not that our minds and our bodies are kind of locked into 1791 when the Second Amendment was adopted, but the amendment has words. And what did the words mean? And if you have to keep the words meaning the same thing, because once you allow courts to just redefine the words, you no longer have a government of laws. You have a government of man. You have arbitrary amendments to the Constitution, basically, is what that amounts to. The so-called living Constitution theory means nothing more than judges get to reinterpret and redecide what the Second Amendment means or any other Bill of Rights.
And overrule what the will of the people is, because that's what we're talking about. What was the will of the people who passed this through Congress and ratified it in the states and made this part of the U.S. Bill of Rights? What was that? So as we look at any amendment to the U.S. Constitution, that's what you're looking at. What did it mean when it passed?
Right. A good example was the freedom of the press. The court always looks back to why that got put into the Bill of Rights. But before the Revolution back in England, you had infringements on the press, and you had them here as well. You had a government procedure where they could prevent something from even being published in the first place. So you have basically censorship in advance, and on that is freedom of the press, or in the case of search and seizure, you had general warrants back in England, and then in the U.S. because of the customs laws, where the government agent could just get a warrant to search for things randomly, to break into your store or your house and search for untaxed contraband, for example.
Yeah, they were called writs of
The
assistance.
Fourth Amendment
That was a big part of the reason for the revolution. Yeah.
Exactly. The Fourth Amendment requires that warrants be specific. It basically prohibits general warrants. You have the protection against unreasonable search and seizure of your person's papers, houses, and effects. And you have the warrant requirement. I know there's exceptions to the warrant requirement that are carved out. They're very narrow. But so you always look at that history when you consider what is the meaning of a right that's listed in the Bill of Rights. And so the Second Amendment is no different. And that's why we look at the history. We look at the founding in particular. And if something was just made up, like in 1911, the Sullivan Law in New York, making it impossible for most law-abiding people to carry a gun, that's what the Bruin case did away with. They said that's way too late in history. We're not going to look at that as a founding era restriction. We're going to look at what took place, what kind of laws did they have at the founding, and in the antebellum period that followed that. And you can go further up in years as long as the laws are consistent with the laws at the founding. So that's the criterion. Some people don't like that because of course, a lot of the gun restrictions were just made up. They go back to like 1968 or even later than that in the case of the law that's at issue here. And by the way, there's one more federal feel-good law that's on that same list. After the protection order provision, if you've ever been convicted of a misdemeanor crime of domestic violence, you cannot have a gun. And it says misdemeanor crime of domestic violence, and I'm thinking defense attorneys are going to say hurrah to that, because the Solicitor General just said to not be law-abiding means you've been convicted of a felony. And here you have a mere misdemeanor conviction deprives you of Second Amendment rights. And by the way, when this was enacted, you had a member of Congress saying things like, oh, these domestic violence cases, they're all really felonies, but they bargain them down to misdemeanors. And I can tell you, I did a lot of criminal work in trial courts when I was younger. And you would have these defendants come in day after day, plead guilty without an attorney to a misdemeanor. And they really were just misdemeanors. They were not, what they did was not to the point of being so violent as to be a felony. And so you have, I don't know, hundreds of thousands of people who pled guilty without counsel to a misdemeanor like assault or battery. And if it happens to be involving a domestic partner, then you're forever disarmed. And so the defense bar is going to see what the Solicitor General said as a major litigation argument in the future. Now, what the government's going to say next, though, is that, well, you're not. If you have misdemeanor crime of domestic violence, you're a dangerous person. You're not a responsible person. And then they're going to have a problem, because what if you were convicted of this offense when you were 18 and you're now 68? And you've lived a life of, you've had a family, you've never had any problems, you've done well for yourself, you've been law-abiding. how are they going to show that person's dangerous? So there's some good that's going to come out of this case, I think. Well, the Supreme Court decisions, I would predict you're going to have the majority opinion, some concurrences, and one or more dissenting opinions. Or I'm sorry, you won't have it. If they uphold the law, there won't be any dissents, but there will be some disagreements with the continuation of the Bruin standards. And also when the court is more specifically applies the Bruin standards to criminal conduct, because remember, Bruin was just about licenses to carry firearms by people with no criminal record. So that the court's going to have to address, here you have a federal criminal law that arises, albeit out of civil proceedings in the lower courts. It's going to be an interesting opinion with different views expressed.
Right, big questions. Due process is at stake here. A possible pathway for a nonviolent offender to get their freedom back. Just important stuff, big questions. What was it like outside the courtroom? I've seen photos of it, and it looked like it was pretty busy outside the court that day.
Well, there were protesters, the usual suspects. They had signs, and I don't know, Moms Demand Action or something. They all wear the same color shirts, and they kind of look like robots. They chant the same thing, and I didn't really see any supporters of Rahimi out there. The case has bad facts, but it's also a bad law. And if you think about it, the Supreme Court frequently finds fault with laws that involve very bad people, including people convicted of murder. And one thing that I think is an observation I want to make about this case, you won't have any of the big law firms doing pro bono amicus briefs in support of Rahimi. But in the case of death penalty cases, you frequently will. So you have these liberal law firms that file briefs in support of really bad criminals who have committed crimes that resulted in death, for example, and they're perfectly willing to do that. But if it's a Second Amendment issue, they're going to be on the other side. If any of those firms file briefs, it's going to be in support of the government.
Well,
so,
Steve, I'd be willing to bet that none of those gun control activists outside that court that morning recognized you, showing how uneducated they really are, because given all your books and all you've done, they should know who you are by this point.
Well, I don't know about that, but they don't like the current Supreme Court. I can tell you that. And you've got the people in Congress who've made it a political issue and have criticized court members. They really would like to get Clarence Thomas, Samuel Alito. They hate them. They even threaten them in amicus briefs. So it's a pretty wild world out there. I think we've got a very good Supreme Court, and we'll see what they do. Que sera, sera, whatever will be. They'll make a decision certainly by the end of June. They could surprise us and do it earlier, but frequently more controversial cases get decided earlier than that. But maybe this won't be controversial in terms of upholding that law. But what's really going to be interesting is the standards that are used if the law is upheld.
Well, thank you for being our guy in the court. How can people find you, buy your books?
I have a website. It's stephenhalbrook.com. And you can just Google my name and America's Rifle, the case for the AR-15, or the right to bear arms, a constitutional right of the people, or a privilege of the ruling class. And there's a lot of other Second Amendment material and other books on related subjects. So just put the name on the internet and it'll come up.
I highly recommend him. Thanks, Steve.
Good to talk to you as always. Thank you for having me, by the way.